Thank you for having me here. This is Martin-Ehlers from the law firm Oppenhoff. I'm giving you some competition law compliance training today in a total of 4 blocks. It will not be exhaustive. I will be just offering you some of the most important topics, probably at present, which are important for daily practicing, but there are plenty of other bunches of topics and bundles behind. Firstly, to shortly introduce myself, my name is Martin-Ehlers. I'm some 25 years into profession. I spent 2.5 years thereof in Brussels, and I'm heading the Department of Antitrust and State Aid Foreign Subsidies at the law firm Oppenhoff in Frankfurt, with a total team of 3 lawyers. The issues that we speak about today are issues that I have experienced in my daily practice, and also partly when we go to courts, be it national, be it European courts. The 4 blocks that I wanted to present to you are, firstly, a general overview over the burdens of an antitrust proceeding led by the European Commission and eventually multiple other authorities. The second one is Article 101, TFEU, the Treaty of the Functioning for the European Union. These are basically hardcore cartels. I will stuck to horizontal agreements because vertical restraints are mostly dealt with by national competition authorities. The third block is 102 TFEU, that is the abuse of a dominant position. Question, what is dominance? What constitutes a dominant position and what constitutes abuse? And the final point, in merger control, an evergreen which has become ever more relevant in the last years, which is gun jumping. So if I can guide you through these 4 blocks, I would like to start with antitrust proceedings and just provide you a general overview. An antitrust proceeding is basically a nightmare for any undertaking because it consumes massive time and resources to organize and to lead it. So every cartel, in a way, is asymmetric. We will come to that. Every cartel will crumble. So the question is really, why get involved at all? What are the potential consequences? First of all, of course, you've got dawn raids from the European Commission. They're very well experienced. They know where they have to look at. They go in when they have information, and they also collect data, massively data. The second thing is that during the proceeding, they will consecutively present you requests for information that you have to answer. Can be very lengthy and burdensome. And then eventually you go into settlement proceedings. That is kind of an amicable way to complete an antitrust proceeding. The European Commission does not have to write a fully fledged decision of several hundreds of pages. Instead, it will be a short decision consented to by the relevant undertaking, but still with a possibility to attack it in court. Nevertheless, the settlement will offer you a significant reduction in the fine. So the consequences of a competition, of an antitrust proceeding, are multiple. First of all, please bear in mind that this is an international issue and has become ever more international. So you may be facing a situation where, for example, the European Commission communicates with other competition authorities, such as, for example, the US FTC or the Japanese Competition Authority. Why am I mentioning this? Because the legal consequences of antitrust proceedings are very different in the different jurisdictions. So as to give you an example, in the US, an infringement of antitrust law can also be a criminal offense, whilst in the EU and also in Germany, it is an administrative offense. But of course, when you think about a criminal offense, you think twice. And therefore, there can be situations where you say, I play it hard with the US competition authorities while I cooperate with the European Commission. So it's very difficult, to find the right balance in a situation where we are facing multiple proceedings in several jurisdictions. So to make it very clear, the European Commission can communicate to the US FTC that there is an antitrust proceeding in the EU. However, no details are being provided. That is prohibited by an international agreement. And furthermore, the way that you present your documents when you cooperate with the European Commission is basically discovery proof. So a US court may not be asking for the documents that you provide to the European Commission. Now, this being said, the entire mechanism is very, very burdensome. In particular, also when you go to the European Commission and you dictate your comments to the proceeding and your findings. So it's very, very burdensome. And to have ultimately the header of the European Commission to get your documents discovery proof. And still, looking into two jurisdictions is a mess. It may even be a bigger mess when you look into more than two jurisdictions. And I just wanted to make you aware that the European Commission is, for the time being, negotiating a new agreement with the Japanese competition authority on the exchange of information relating to antitrust proceedings. The next point is that you need massive resources in order to handle an antitrust proceeding. You need internal audits. You need to interview the relevant employees. Eventually, these employees will have separate legal representation. They will potentially ask you, for privilege, and you will probably grant it because you need the information that they have and that you as a company are not aware of. Things may become difficult if we're talking employees that have already left the company because they retired or something. So information collection is a massive issue. You will have to consider to inform your D&O insurance and the question whether the insurance covers whatever is the result of the antitrust proceedings. If you're a stock floated company, which is listed in a German stock exchange or whatever other stock exchange, you may consider that you have so-called ad hoc measures, which means a communication to the public, because in informing the public that there is an antitrust proceeding has been initiated, so as to comply with your duty to publish facts that may severely impact the rate of your shares at the stock exchange. Finally, you also need an alignment with the auditors, which is the question, do we have to create an accrual? How do you calculate the accrual? And the accrual should cover potentially a fine at the end of the proceeding, but also eventual claims for damages. The next consequence are fines, which is a severe consequence. In the EU and in Germany, it's a maximum of 10% of the total corporate group turnover worldwide achieved in the last completed business year. And there are calculation formulas used by the European Commission, which also take into account the duration of the infringement plus the gravity. And I can tell you that there is just one tendency for fines in the last decades, and that means they've been going up. So it becomes extremely expensive if you repeatedly infringe competition law. There are cases, and we will revert later to one like Michelin 2, where you have companies that have several times separately infringed competition law and have to pay massively fines. In the EU, you will only be fining the relevant corporate entity, however, with the consequence that also the parent company is liable if, for example, an affiliate company infringed competition law. In Germany, there is something that comes on top, which is that high-ranked individuals can also be fined. And that is something that the German Bundeskartellamt, the German authority, has in fact practiced in the last years. So in the second cartel on the pharmaceutical trade or retail, there was an experience that not only companies were fined, but also individuals like CEOs or members of the supervisory board. And then, of course, you will have questions, as to what will happen. Can the company reimburse that or not? Oh, it's a difficult issue. Finally, in Germany, there's also a provision which may lead eventually infringements against competition law into a criminal offense. This is section 298 of the Criminal Code. I will not go into the wording. The key idea is that this provision relates to bids. So if you have a situation where the contracting party, which needs a certain supply, runs a kind of a tender proceeding and asks multiple potential suppliers for their offers, then an antitrust communication between those suppliers, a bid rigging, can constitute a criminal offense. First of all, the provision covers bid rigging when there is a procurement proceeding by a public authority. That is quite clear. What is not so clear from the wording, but what is established, is that also when a private company asks for supplies, then a potential bid rigging is also a criminal offense. So bid rigging would be something to define it as to say, for example, supplier A talks to supplier B and says, look, we've been asked to provide an offer to this company and you too. I will provide an offer for the price of X. You will provide an offer for the price of X plus 5. So you are formally offering a higher price, which means I will get the contract. And we will then do the revert game, for example, in your region. Or I will pay you a premium, or I will subcontract you. So any kind of interference with the procurement proceeding may lead to criminal consequences. Finally, you're facing a situation where you may be confronted with claims for damages from your customers, and there may be cases where those damages may even be higher than the fine that you have to pay. Such claims for damages are difficult to negotiate because if you have a cartel infringement by several companies, you need to be somewhat aware who said what, who did what. You may be facing a situation where one of your customers may have received documents from the antitrust proceeding from another cartel participant, and you are joint debtors. So it's a difficult terrain to move. It's also a very commercialized terrain, at least in Germany, with a multiple number of US law firms having moved into it, but also financing institutions. And there is also a real industry for economic consultants which offers so-called regression analysis. So the question, has the infringement in fact led to a damage? Has it caused a damage? And for that purpose, they would analyze a comparative market, eventually at a comparative time or a time before or after, and try to establish on economic terms whether there has been a damage. Now, as you can imagine from all I told you, this is all very costly and in particular time consuming, so it should be, in principle, by all means avoided. This completes the first block, and I would then move on to the second, which is the prohibition of restraints of competition by Article 101 of the Treaty of the Functioning of the European Union. What is it that this provision prohibits? It prohibits restraints of competition in three forms. Two are quite international. One is a European peculiarity, which also differentiates us a little bit from US law, and we will go into that later in detail. So the three categories that I will talk about are agreements between undertakings, decisions by associations of undertakings, that is in particular association meetings, and finally concerted practices. These are the three elements that I would like to guide you through and give you an idea. Whilst doing so, I will focus on such agreements between undertakings which are horizontal, meaning these are agreements between undertakings that are on the same economic level. That would be, for example, an agreement between producers or an agreement between distributors. It would not be an agreement in a vertical sense between a principal producer and eventually a reseller. This is not where I'm going into, because this is mostly an issue of national competition law and being dealt with by national competition authorities. Prior to going into those three systems or three categories, I wanted to explain you, like in a ruler format, how the European competition law applies in practice. So we have the prohibition of the three categories, which I mentioned in Article 101, paragraph 1, TFEU. And then, of course, we have a possibility to justify them in broad terms, and that's a twofold possibility. Eventually, this prohibition is exempt, or this category that we're talking about is exempted from the prohibition by so-called block exemption regulations. And I'll come to the mechanism of that in a moment. Or ultimately by Article 101, para 3, TFEU. So there are two possibilities of justifying an infringement in terms of restraint of competition. But be aware, these possibilities of justification are limited, and they do not apply to hardcore cartels like price fixing, quota fixing, attribution of customers or territories. That doesn't work. But there are specific possibilities to deal with restraints of competition in that system. In the following, I provided for you the text of Article 101, para 1 TFEU, and you can see that it prohibits the three categories that I've been talking about: agreements between undertakings, decisions by associations of undertakings, and concerted practices. And it even provides you with a non-exhaustive list, an exemplary list of what these three categories cover, like direct or indirect fixing of purchase or selling price and these things. But as mentioned, this list is not exhaustive, and there can be many other infringements. Let's go through it. So let's assume for a moment that there was a restraint of competition. And let's ask for a moment, where could the potential justification lie? Let's go into the mechanism of the block exemption regulations, which I mentioned previously. So the block exemption regulations are basically divided into two categories. The first one is horizontal agreements, and the second one is vertical agreements. There's even a mixed form, which are technology transfer agreements, and I'll come to that in a moment. So what is the general system of the a block exemption regulation? The block exemption regulation will tell you everything which is not explicitly prohibited by this regulation is allowed. So in the sense that allowed means is exempted from the cartel prohibition in para 1. However, that system only applies up to a certain market share threshold. And for that market share threshold, you will have to look at the different participants in the agreements. And the market share thresholds are, of course, different because they're different sectors. And this requires economic analysis. What is the market? What is our market share? What is the potential market share of the other participants? So let's go into the examples. Examples for horizontal block exemption regulations are regulation to specialization agreements. What is that? Well, specialization agreement is something like two companies meet and agree it doesn't make sense for both of us to produce the same product. There are overcapacities in the market, it's too expensive. So company A will produce it. Company B will cease the production, but source its demand from company A. So it can be unilateral, it can be mutual. There are several possibilities for such specialization agreements. And as I mentioned, everything is allowed in this area as long as there is a specialization agreement, as long as there is no explicit prohibition and the respective market share thresholds are not exceeded. That needs to be analyzed in detail. Then you have the possibility of exempting certain categories of research and development agreements. I think I don't have to go into detail what that means. And there are furthermore additional guidelines of the European Commission on horizontal agreements, which shed light onto other forms of horizontal cooperation, like, for example, the formation of purchasing groups, which, we'll come to that, is allowed under certain circumstances if a certain market share threshold is not exceeded. Now, when I shift to vertical block exemption regulations, it's the very same system, but it's on the vertical side, which I did not want to touch and go into detail too much. But we have the general regulation 330/2010, which basically provides the codified law for any kind of distribution. So this would be things like, for a reseller, the prohibition of resale price maintenance, the question of exclusive distribution, the question of a non-compete, and a very specific definition of a non-compete, which may not be fitting to every industry sector. And again, the regulation provides everything is allowed if there is a vertical agreement, provided that it's not explicitly prohibited by the block exemption regulation, and provided that the relevant market share threshold is not exceeded. Now, there is also vertical guidelines of the European Commission, which are like a manual for the operation of the block exemption regulation, and you will find many additional cases being explained there. And questions, for example, on the calculation of the relevant market shares. So that is a very helpful document. Although, as I need to mention, these documents are limited in time. And whilst I'm taking you through this competition law overview, there is a renovation of this regulation ongoing, and we will be looking in due time at new rules that the European Commission will provide to us in this segment. Finally, there are also, as I call them, hybrid block exemption regulations. For example, on technology transfer agreements. And hybrid, I call them because they cover, likewise, horizontal agreements, but also vertical agreements. And you first need to establish whether you have a technology transfer agreement, whether it's horizontal or vertical. And then you may even go further down. For example, if it's horizontal, you may have to check, is it unilateral, is it mutual, and all these things. And you have to really tick off boxes. And again, the question is, do the parties exceed a certain market share threshold, yes or no? So the idea is really know your markets, do your assessment, and when looking at the markets, you have to look into the precedent, in particular of the European Commission, but eventually also other competition authorities. And I can tell you already now that there are cases where one competition authority defines the market in form A, and another competition defines the market in form B. We'll come to that later, and it presents a massive burden in the economic operation of everyday business. Can you have explanatory guidelines on the application of the technology transfer agreement, which is, as the vertical guidelines mentioned before, but a manual for the explanation on how to operate the technology transfer regulation in day-to-day life. So you see, there are a number of possibilities to legalize cooperations with a competitor. It can be specialization agreements, it can be R&D, it can be technology transfer. But as mentioned before, hardcore cartels like price fixing, allocation of customers or territories are never justified. So we don't even have to look as to whether there are block exemption regulations. There aren't. When analyzing the block exemption regulations and the list of the clauses that they prohibit, and that can be very long lists, can be so-called black clauses or gray clauses, you may be facing a situation where even though you may comply with the block exemption regulation, your market share threshold is higher than the one provided for in the block exemption regulation. And that again would lead to a situation where the block exemption regulation does not apply, and it does not provide you the comfort that you need. So the ultimate, let me call it, defense line would be the direct application of Article 101, Para 3 TFEU. This is a general exemption. It is the provision on which ultimately all block exemption regulations are based conceptually. But as mentioned, if you exceed the market share thresholds, then you may need to recur to 101, Para 3. So the idea is that you exempt certain restrictions of competition from the prohibition in Para 1. If, on the other hand, and you counterweigh, you have benefits from such restraint. So it must be something that enhances and improves the distribution of goods, or which promotes technical or economic progress and ensures that ultimately a customer or a consumer will have a fair share in this technical development. You have additional provisos and caveats, such as that the restraint of competition may not be indispensable, which is a kind of a proportionality test. And of course, it may not be used as an excuse to significantly impede competition in that very sector of the industry. So contrary to the wording of para 3, this is a provision which leads to self-assessment. So you, as the unaffected undertaking itself, have to verify, is this provision applicable to me and the cooperation with my competitor in the case at present? And these are difficult tasks for a competition lawyer when a client comes and says, look, I know that the block exemption regulations don't apply, but I think we have a specific case here because we, in reality, foster the technological development. We want to nurture the progression of industry in our business segment. And therefore, I need the self-assessment. I provide you with the relevant information, and you please evaluate, do we fall within the scope of para 3? And do we fully fulfill all conditions set by this provision? That's a difficult topic in practical law, and mostly these legal opinions are being written for the drawer, but they should be taken out of the drawer from time to time in order to verify whether the clauses and pre-requirements of para 3 are still met. So this is the entire system of the competition law here. So we have the prohibition in para 1, prohibits restraints of competition. We have a possibility to justify by 2 elements, which are eventually block exemption regulations, or finally and ultimately Article 101, para 3 T4. So this is the daily business of a competition lawyer. This is like fork and knife when you're trying to set your plate and module the elements of a specific case, like it was a piece of food. It is know the block exemption regulations, know the markets, know the eventual market share thresholds, and your own assessment, which may be difficult in practice. This being said, and having led you through the system of competition law, I would now like to go into specific examples. As previously mentioned, para 1 prohibits 3 categories of restraints of competition. One is agreements between undertakings. And that could be horizontal agreements, which we talk about here, or it could be vertical agreements, which, as I mentioned previously, I will carve out because they are mostly being dealt with by national competition authorities. So horizontal agreement can be any kind of agreement between competitors, and it does not need to be an agreement which is formalized. It does not have to be an agreement in writing or sealed and stamped by a notary public, even though sometimes there are even cases where you find restraints of competition in a notarial deed. It's just an understanding between competitors which is lived in practical life. To give you an example, in Germany, some years ago, there was a cartel on the procurement of railway systems, so the iron railways and other accessories for public transport. And the members of this cartel were participating in bid rigging, partly saying, look, I apply for this procurement, you apply for that procurement, and they communicated very smartly. They communicated prices and the way of behavior by talking about the weather or by mentioning results from sports events like the German soccer league. This was nothing but codified language about what the parties really intended and wanted to do, and it was an agreement between undertakings. And it doesn't matter whether the employees involved are really legally entitled to represent that company or not. If it leads to a coordinated behavior, then you're caught. And that's about the worst thing that can happen. So I wanted to take you through some subcategories of agreements between undertakings, and the question, what can be eventually justified and what is a definite no. So one possibility are trade supplies that may be justified in specific cases. For example, you have a customer, but you are running out of stock. So you're asking a competitor, can you please provide either me with the products or directly my customer? I cannot for the moment supply to him. These kinds of very spontaneous one-time agreements, I'm out of stock, can you please? That is in principle not an issue. It becomes a problem when it grows into a pattern of customer and territorial allocation, which should not happen. Joint bidding is another issue. So we in European competition law don't really have what the US Americans would call a rule of reason. But joint bidding can be one of the cases where competition law does not apply. Let me give you an example. I will revert to a procurement proceeding where you have a situation that a new highway shall be built from city A to city B. And of course, there are procurement proceedings for, say, kilometer 0 to 10. That is one public contract. Kilometer 11 to 20. Kilometer 21 to 30. And then you have a scenario where the participants in the procurement proceeding would be all important, say, national players or even international players, construction companies with deep pockets that are very strong, and they would all apply for these or part of these contracts. And then on the other side, you may have a situation where you have two small or medium-sized companies, none of which could really participate in the tender proceeding because they themselves alone could not construct kilometer 1 to 10 or 11 to 20. So they joined forces. And in doing so, they say, look, neither of us can do this job alone. Together we can. So they form a kind of corporation and try to secure it with a certain exclusivity and say, look, we will apply together for this project. And when doing so, we will cooperate exclusively. None of us will cooperate with any of the other potential or actual bidders. And this exclusivity is seen as a non-infringement of Article 101, Para 1. It is not a restraint of competition for the simple reason that the cooperation of these two small and or medium-sized companies creates a new player, a new competitor, somebody that can eventually put pressure on the other bidders simply by participating in the tender proceedings. So in this case, joint bidding with a securing exclusivity would not constitute a restraint of competition. Joint purchasing is another topic which I mentioned previously, is a topic that is dealt with in the horizontal guidelines of the European Commission, which I mentioned previously in the slides when dealing with the horizontal block exemption regulations. So in principle, joint purchasing can be allowed. As set out in the guidelines, it says, there is unlikely that market power exists if the parties to the joint purchasing arrangement have a combined market share not exceeding 15%. But this market share threshold applies to two different markets. It applies on the one hand to the sourcing market, and applies to the market where you sell off the goods that you try or intend to purchase jointly. So the threshold of 15% has to be measured against the sourcing on the one hand and the sell-off market on the other. So it can be that you purchase certain products, and these are just intermediate products, and you will relabel them or integrate them into other products and combine them and sell them off. So the 15% market share threshold will apply to the sourcing market and the sell-off market alike. Now, this does not mean that if the joint purchasing agreement leads to an exceeding of this 15% market share threshold, that you would automatically be infringing competition law. It would not automatically mean that there is a restraint of competition which cannot be justified, but you would then be in the difficult situation that eventually you would have to justify this joint purchasing under Article 101, Para 3, and all its very soft formulations that I mentioned previously when guiding you through this provision. Things like an enhancement of technology, participation of the customer or consumer, a proportionate restraint of competition, and so on and so forth. So these are the areas where you may be moving in when you exceed the relevant market share threshold for joint purchasing agreements. Now, as previously mentioned, I wanted to guide you very quickly through some of the vertical agreements, which I will not be dealing with here. These are exclusive distribution agreements, maybe selective distribution systems, maybe license agreements under the technology transfer agreement. And just to make one thing very clear, resale price maintenance is never admissible. And to give you an example, under the German practice, this is a very broad concept. So even if a producer becomes aware that a reseller is selling at a price which is lower than the recommended sales price, and he says, look, I know what you're doing. You're selling below my recommended sales price. Even this one-time call, this making aware, could lead to pressure on the reseller and then respectively constitute a resale price maintenance. Don't go into that area. Other topics are regional exclusivity. Become, for example, the exclusive distributor for Germany or parts thereof for France, and so on and so forth. Non-compete obligations and these things. And that needs to be measured against the rules of the block exemption regulation. This completes my explanations of agreements between undertakings And I will now move on to the second category. The second category are decisions by associations of undertakings. That's in practice a rather narrow concept, which really applies in particular to association meetings. So if you and your competitors meet at certain association meetings, maybe an association for the pharmaceutical industry, for the chemical industry, or whatever, and discuss trends of the industry and topics, be aware competition law applies to this scenario as well. And watch out what you'll be doing, because this is a source for terrible mistakes that can be made. So what is unproblematic is a membership in an association. The participation in meetings of the association or sector meetings for certain regions or countries talks about the general market situation or the raw material situation. What will be the future? Will we have other raw materials? Where will they come from? All this is not an issue. But what becomes problematic are, and we'll get to that in a moment, talks on specific prices, allocations of customer territories, meaning ultimately the association is being used as a platform to agree upon and implement agreement between undertakings. So you use the organizational structure of an association in order to provoke and cause an infringement and a restraint of competition. That could be alike quotas and capacities restrictions, or talks on supply and payment conditions that you have agreed upon with certain customers. So even the detailed information about your customer structure may be an issue. So watch out, because everything aimed at coordinating market conduct, or which might be understood as such, may be caught by this second category of Article 101, Para 1 T4. What does that mean in practice? It means that you should be careful with your language when participating in association meetings. Careful when you draft protocols of such meetings to say, do not use specific wording that indicates the existence of a restraint of competition or may be understood as such. Watch out when you use language like destroy after reading. Be very careful and try to avoid wording like market dominant position, price leader, or anything that may even suggest collusion, like the term sectoral agreement. Of course, you may be facing a situation whereby on the occurrence of such an association meeting, other undertakings engage in these conversations. But you would not do that. And I recommend it to take countermeasures, such as to stand up and contradict, to have your representative employee leave this association meeting, and to make sure that his contradiction and the fact that he left the association meeting is properly being represented in the protocol of the meetings. That's very important. So if something happens, raise the finger, stand up and leave. Just to give you an idea to what we're dealing with sometimes in practice is a situation where the compliance organization of a corporate entity becomes aware of something like that, and then it reverts to the competitors and says, look, we've been informed that this and this happened, and be aware we are a zero tolerance company. We don't participate and become involved in these kind of conversations and so on and so forth. So I don't know whether this kind of, say, forward strategy is more useful to really lay a paper trail on what happened. But the important thing, as mentioned here on the slides, is make sure the contradiction is documented, as well as the leave of your representative. This would now lead me to the third element and category of a restraint of competition, which is concerted practices. Now, concerted practices is a term that is legally hard to grasp. It is so wide that it becomes difficult applying it in practice, and it is the introductory door into every kind of compliance organization that you may eventually be setting up, and is also a peculiarity that to some extent differentiates European competition law from, for example, US competition law. Now, first of all, I want to explain what is not concerted practice. What is not concerted practice is an independent parallel conduct. So if economic operators and companies that are facing the very same economic surrounding, sourcing of raw materials and other issues, when they behave in the same way, not because they have a certain understanding, be it outspoken or not, but simply for the fact that they individually adapt and use market intelligence. To give you one example, which has always been looked at very critical in the past, when you have holidays and you drive with your family to the sea, and you will be angry because every time you do that, the petrol and gas prices are extremely high at the time of the holiday season. And you would consider or suspect that the oil producers are involved in some kind of concerted practice, whereas they would always return and argue, look, we are independently responding to the market. It's the spot price of the petrol when it arrives in Rotterdam as the key harbor of the European Union for these things. And we all have basically to do and to act in order to match these, say, standard situations in the market. So a independent parallel conduct is fine, but a concerted practice is a problem. So let me give you the totally opposite example. If I was the CEO of a company and at the same time I was an avid private gardener, and if on the other side of the street my competitor B would reside, and each time I consider to raise prices, I put in a stock of flowers in my window, and the competitor which watches my window could eventually consider, aha, it's a flower stock, so he will raise price. Or if I put in 2 flower stocks, and it would means I decrease price. This is not independent parallel conduct. This is clearly a concerted practice. Abstain from it, whatever type of gardener you may be. So the one thing this provision catches and has been catching in the past, so-called market information systems. This is the case John Deere. It was basically an institutionalized market information system. It was not really about prices, but it was like, these are the distribution areas, this is the volume that I sold, and so on and so forth. And since the market was small and rather transparent, each member of the association could really deduce, aha, he's been supplying XYZ in that region to that customer and so on. So this market information system was so perfect that it made the market basically transparent. And this case from the mid-90s ultimately led to what is now a key issue of concerted practices. That is the prohibition to exchange commercially sensitive information. Now, the European Commission takes the view, and this has been confirmed by the European courts, that an exchange of commercially sensitive information adds to the transparency of the market. And by increasing the transparency of the market, you at the same time decrease the economic risks that are inherent to your activity as economic operator. And that means that an exchange of commercially sensitive information enables the companies participating in it to collude. And this ability to collude is a concerted practice. So what is a commercially sensitive information? And I have to tell you, this is a very good question. The European Commission, in its horizontal guidelines, provides some guidance, but once again, a non-exhaustive list. So they quote that the sharing of strategic data can give rise to restrictive effects on competition, and quotes, strategic information can be related to prices. For examples, actual prices, discounts, price increases, reductions or rebates, customer lists, production costs, quantities, turnover, sales, capacities, qualities, marketing plans, and so on and so forth. Now, this is a very, very broad concept. You need to be very, very careful when exchanging such, say, type of information or intending to exchange such type of information with your competitors. Why is that? First of all, because the exchange of such commercially relevant information triggers the presumption of a concerted practice. If you do it, you are considered to have a concerted practice, and you, as economic operator, have the burden of proof to prove otherwise. And I can tell you from my experience that until today, no economic operator, no undertaking has been able to rebut that presumption of a concerted practice. In fact, this has already been tried in court once in the so-called banana cartel, where the members or participants in the cartel argued, look, the employees that were involved in the exchange of information, they were not entitled to fixed prices. They were not entitled to represent our company. And still, the European Court said, this is not sufficient to exempt you from this presumption. Furthermore, and this is what makes the provision really a hardship in practice, a one-time exchange of commercially sensitive or strategic information is sufficient to trigger that presumption of a concerted practice. And again, this has been tested and confirmed by the European courts in the case T-Mobile Netherlands. So watch out when you exchange this information. Watch out when you exchange information over the platform of an association, and only do it in specific forms. Use not actual, but elder data. Make sure that the data are aggregated and to a certain extent eventually anonymized. If such exchange of data shall be used, for example, to present trends in the industry, where are we going to, what will be a future scenario. So be careful. And I wanted to present you, as last part of this second chapter, a situation where this exchange of commercially sensitive information regularly has massive importance. This is in the M&A sector, when a competitor tries to acquire another competitor. And of course, when doing so, you have a due diligence procedure, and you will learn about economic core data of your competitor. Now, furthermore, assume that you learn about these data and then you break off the negotiations. Or ultimately, the target competitor is being sold to somebody else, strategic investor, private equity company, and you still have all these raw data. And therefore, you know exactly the position of your competitor and could potentially use this information in the markets and in day-to-day business. So what is the repair possibility for such a situation which occurs every day in practice? It could be a so-called clean team solution, either clean team clause to be mentioned in a non-disclosure agreement or a separate clean team agreement. The idea of clean team is, in theory, that you take on a need-to-know basis certain employees from one team and from the other, so from potential purchaser and seller, and that you share this information and that you keep it in the clean team until the very point in time that the information has ceased to be actual. Now, this is a very theoretic approach because it will take time until the information becomes old and potentially too much time. So what happens in practice is that you disclose this information, but in a step-by-step approach where the ultimate information that you need to make, for example, the decision on whether to purchase a company or not, is being relieved at the very last stage. So it's really a step-up proceeding. Again, details depend on the case that you've been dealing with. The only thing I can convey here is watch out when a competitor tries to acquire another competitor. Just think about and remember the clean team approach, and details can be arranged and fixed in the relevant case. Now, this would complete the second block. And before revolving to the third block, I would have a short break so I can drink some tea. Is that fine?